Hey guys, and welcome to today's video. Today, we have 3 hearings to cover, starting with the return of Super Sovereign Eric Martin, who needed to find a way to end up back in court so he could remind all of us that he's still a living man. Now, I'm not so sure about the man part, but I can 100% say that he's living proof that I know what I'm talking about. Because I always say that this won't be the last time we see whatever SovCit we're watching that day, because they don't believe laws apply to them, so they'll be back. Well, Eric Martin's back, so let's begin.
Your name, sir, for the record.
I'm at your Roman Sesticate Trust legal fiction corporate entity defendant. That's what you want to know. I am one of
Okay,
the
well, this,
sovereign people.
okay. All right, so this is for Eric Joseph Martin. And officer, can you tell me the person that's standing before you, who they've been identified as far as your records?
Yes, Your Honor. This is Mr. Eric Martin.
Okay,
I object to that any presumption that I'm a legal fiction corporate entity. I am a living man whose name is spelled capital E lowercase RIC of the capital M lowercase ARTIN family, one of the living people living on the land.
Well, for the time being, you're living on whatever floor they assigned you to at the county jail. And just look how the uppercase human tries to hold in his laugh as the lowercase dipshit goes through his sovereign routine.
Not the corporate
Okay.
entity defendant.
sir. All right, it's time to listen right now. Thank you and good morning. The court is calling case number 282-257-13-64001. The people of the state of Michigan versus Eric Joseph Martin. Appearances, please.
Jasmine Martin, P86378, appearing on behalf of Mr. Martin, Your Honor, who indicated that he wishes to represent himself, pro se.
Okay. All right, so Mr. Martin, this is an arraignment. And it's the court, never advises the individual to represent themselves, but you do have that right. You do have an attorney that's here that had an opportunity to speak with you. What's your position as it relates to this arraignment? So you'll need to know how to follow court procedure if you want to represent yourself.
I have a motion I want to make on the matter at the battle. Move to dismiss based on lack of probable cause. My sister just told a lie saying I put my hands on her. I told the cops, no, I did not. That is not fact sufficient for the belief, as the U.S. Supreme Court said, and if I remember right, it's Beck versus Ohio or Ohio versus Beck. It's a U.S. Supreme Court case. Define probable cause as fact sufficient for the belief. There is no fact
Okay.
for the belief. There is no probable cause. I was arrested illegally. I want the cops charged also for arresting me illegally, which is assault and
Mr.
battery.
Martin,
Hold on,
Mr. Martin,
it's kidnapping.
no. What we're gonna do, because I want to tell you this, you could challenge the complaint. You'll have a probable cause hearing and you'll have an opportunity to confront your sister at the preliminary examination. If she's not being truthful and the court hears that, then your matter will be dismissed if the court doesn't find probable cause. And if the court does, then the matter will be bound over. But at this juncture, I'm just arraigning you, sir. And that's all I'm gonna entertain today. I'm not entertaining any motions relative to dismissal. The probable cause has been established.
I object.
It's arraignment. You can object, and your objections are noted for the record, okay? But I'm just arraigning you. I'm just gonna set a bond, and you'll challenge those matters at the next court hearing, okay?
But I have a right still to challenge it now because the officer filled out the complaint form. He's lying by saying he believes I committed. He can't just go off her word and say, "Oh, I believe he committed a assault or whatever or a crime." He's committed perjury just by doing that. I shouldn't be arrested, let alone still be held here. That's what I'm saying. This is all illegal, violation of my due process rights. So, you shouldn't just be referring to a future date, whatever. Yes, we know that's true, but I'm saying as of right now, though, the issue is still ripe now to decide. It was no probable cause. I shouldn't have been arrested. I should be here now. The charge is dismissed. There is no evidence here.
Talk over me, Mr. Martin.
My
Mr.
sister
Martin.
been caught lying before on video, which in another case was dismissed in my favor for her same lying self, and she was on video caught lying. This is why the judge dismissed.
No, I covered most of that case, and while I didn't cover the conclusion, Colin did cover it, and it wasn't dismissed because your sister was caught lying on camera. It was dismissed because the witness didn't show up to court.
That's
So she
enough.
really has no credibility.
Listen to the court right now. You'll have a chance to take care of those matters later. You'll address all those issues. The court is not trying to be rude. I'm going to arraign you. So I'm going to tell you what you're charged with. It indicates in the complaint that on 6/12/2025 at 9074 Clifford in the city of Taylor, indicates in count 1 that there was an assault or an assault and battery upon Lisa K. Martin. Sir, that is a misdemeanor that carries 93 days and/or you could be fined $500. You also have in count 2 a charge of domestic violence. That is also a 93-day misdemeanor. It indicates that you did make an assault or an assault and battery upon Lisa K. Martin. Again, these are just allegations. They're charges which you have an opportunity to challenge. This is an arraignment. I am going to enter a not guilty plea on your behalf. And officer, do you have any information relative to Mr. Martin's background?
Man, they previously had a lot of domestics with each other. He does not have any ongoing cases at this time, though.
Okay, so Mr. Martin, I understand that you were living at that location, but the court's not going to permit you to return there. You're going to have to find another place to go while these charges are pending.
That's the house I live in. I don't lose my due process right. It violates my due process right. I can't live there because she makes up a lying allegation. I do not lose that right. That's my right.
You have a pretrial that's scheduled for June the 23rd. You have a pretrial scheduled for June 23rd at 9 o'clock. There is a no contact provision, and you cannot return to the Clifford location. And if you do, sir, that'll be a violation of your bond, and you will end up back before a judge in Taylor to address that. So thank you and have a great day.
Violating your oath of office, you'll be forfeiting your job. That's violating my constitutional right. I do not lose my right to be free just because someone tells a lie with no evidence. That's why I said this case is dismissed now. There is no evidence. There is no probable cause. You do not have the right to tell me I can't go here or go there or be at my only house that I have a right to be at, or leave this state and all the rest of the bull crap orders you judges like to just do traditionally. Like it's okay. It's violating people's human right. It's violating our constitutional due process. You judges are going to stop this with a class action lawsuit. I'm going to make you guys stop this habit that you're doing. So you might stop it now. Like I said, I'm not. It's not going. You're not going to get away. I'm going to get away with violating my due process rights. Telling me I can't be at my house.
I'm done with this matter. Thank you, Mr. Martin.
House to go to anyways.
Okay, I'm done.
What is her name? Correct. What is her name?
Okay. Have a good day, Mr. Martin, sir. Take care. All right, we're done. Thank you, officer. Take care.
Thank you, Your Honor.
All right, so it looks like Eric Martin got a bond of some kind, and maybe I missed it, but I didn't hear her say a specific amount or if it was a PR bond or not. Now, I did hear her give him bond conditions, and I did hear him say that he has no intention of following those conditions, so I've said it before, and I'll say it again, he'll be back. So now we head to Kansas, where we have a continuation of sorts. You see, last week I covered a Karen from Kansas who took the Safe Light Challenge and failed, then acted like an idiot in court. Well, today we have one of her fellow sovereign citizen cult members in front of Judge Ricky, who's about as no nonsense as they come. And just like the young Karen we covered the other day, he'll be reading from his sovereign citizen script that he brought with him. Coolin' with Colin shared this video with me, and a link will be in the description if you want to go over and give him a sub.
Take up Quentin Height next. This is the state of Kansas versus Quentin Lawrence Height. It's case number 2025 TR 1215. Quentin Height appears apparently on his own Zoom. Jaron Regier appears on behalf of the state of Kansas and the Butler County Attorney's Office. For Height, court has an information before it which alleges in count 1 the charge of interference with law enforcement, a Class A non-person misdemeanor punishable by up to $2,500 fine and up to 1 year in the county jail or both. In count 2, failure to register a vehicle, an unclassified non-person misdemeanor, punishable by up to 30 days in the county jail and up to a $500 fine or both. What are your intentions regarding a plea here this afternoon, Mr. Hyde?
Good afternoon. I do not intend to plea.
Why is that, Mr. Hyde?
I have a few clerical things I'd like to clear up. Did you personally read the case filing for BU-2025-CR-000261 in its entirety?
No.
Do you believe that the filing document is true, complete, and correct?
I'm not sure why I'm answering your questions, Mr. Hyde. We're here on a first appearance on a criminal case.
I am trying to clear up to make sure that the charging documents are true and correct before proceeding.
I see nothing openly defective about the charging document.
Okay,
Well, let's move on. If you don't wish to enter a plea, the court will be entering a plea of not guilty on your behalf, Mr. Hyde. And we'll be establishing another court date.
Your Honor, that would not be my preference. I would like to have.
Well, I don't care if it's your preference or not.
Thank you. I would like to have a probable cause hearing before a plea.
You're not entitled to a probable cause hearing. This is a misdemeanor case rather than a felony case, and you're not in custody.
Uh-oh, it looks like they forgot to cover that in whatever sovereign citizen law school you attend on Google. Because in Kansas, the only cases that have a probable cause hearing requirement are felony cases. And as the judge said, these are misdemeanors. He also said that you don't get a probable cause hearing because you're out on bail and not in jail. Because defendants who are going to have their liberties restrained for an extended period of time post-arrest have a Fourth Amendment right to have that determination be made by a judge. And that's backed up by Supreme Court case law, Gerstein v. Pugh. So no, the court won't be wasting any more than the necessary time needed to find you guilty.
Okay, I have challenges that I would like to raise on the record formally for both the case filing and the field case report from the arresting officer.
Let me ask you, do you believe that you have the financial resources to hire a lawyer to represent you in this case?
I will not be hiring a lawyer. Thank you for asking.
So you're going to represent yourself in this case, is that correct?
I will be presenting myself. That is correct, yes.
You do understand that if you can't afford a lawyer, the court will consider appointing you one.
I do comprehend this. Thank you.
But you reject either retained or appointed counsel, and you're going to represent yourself in this case, correct?
I will be presenting myself.
Very well.
Thank you.
There was an appearance bond posted in this case. Apparently, it was a cash bond in the amount of $2,000. It secured the defendant's appearance. The court has approved that bond and will maintain Quentin Height under it pending further proceedings in this case, which I will set.
Before that, I would like to request your lawful determination that this court has jurisdiction over this matter, as I cannot proceed until the field case report and the case filing are both verified complaints and true and correct.
I don't know where you're getting all this. According to the state's charging document, I'll advise you, Mr. Height, that it did take place somewhere in Butler County, Kansas.
Okay, thank you for that.
I do believe it has jurisdiction.
I do have a copy of a field case report and a case filing that I received from the Butler County Attorney's Office as well as the Butler County Sheriff's Office, and I have found inconsistencies in both of the documents that I'm trying to raise here formally with you that I cannot make a plea until they have been resolved.
All right. So I've entered a not guilty plea on your behalf.
I would like to please the court that this would be not on my behalf and under threat and duress, and only under the matter that you have moved on my behalf. I have not entered a plea.
All right.
Additionally, I'd like to let the record show that due to a lack of corpus delicti via verified complaint, jurisdictional defects, and the lack of essential elements to bring a formal complaint and charges against me, I must move for dismissal immediately based on the plaintiff's failure to present all the required elements. That is in regards to the case filing.
You gotta love Judge Ricky. Once he smelled the brown crayons on his breath, he knew he was going to be denying that motion.
Judge, I would also like to ask, will you be reviewing the case filing and field case report in their entirety to ensure that my due process rights are not violated before the arraignment hearing begins?
Court's going to assign the case to this division. I'm going to set a court date for Monday, August 25.
And what is the purpose of that court date, may I ask?
For further proceedings in the case, Mr. Height. It'll
Okay.
be your first appearance with following today's date. I'm going to set
Would
the
you
hearing
repeat that again?
time at 3:00 p.m. You may
My
appear
apologies.
by Zoom.
Is there an
3
in-person?
o'clock Monday, August 25 for further proceedings in this case before this court.
Thank you. And may I ask, is there an option for an in-person appearance?
Not for that court appearance.
Okay.
We'll conduct the next appearance by Zoom.
Okay. Is there an opportunity to be in person for any proceedings?
Yes.
Okay. And
But-
which proceedings would those be?
But what we've established today is the next one will be by Zoom. Now,
Okay.
if you don't want to appear remotely, you can come to the Butler County Judicial Center and you can participate from that location. You'll be participating by Zoom, but you can participate from the Judicial Center. So make
Okay.
sure that you have the resources available to you to fully participate in the next hearing. So Monday, August 25, 3:00. He's going to represent himself. And the court has approved and maintained him under his previously established bond of $2,000 cash.
May I also ask what
Okay,
judge
just a
and
minute,
what
I'm going to ask the prosecutor. Mr. Regier, is there anything else that we need to address regarding Quentin Height at this time?
Not on this particular matter, Your Honor, although in per my duty of candor as an officer of the court, I would tell the court that there does appear to be another case involving this same defendant, where it would appear that an appearance bond has been executed for at the end of next month. I'm not sure, given the court's orders today, if the court wishes to address that matter at this time for the purposes of the judicial economy.
No. If he has multiple cases, that's the implication of having multiple cases, that he may have multiple court dates.
Very good. Your
So
Honor.
let's go ahead and cite for Mr. Height, just in case he doesn't have it written down on his calendar somewhere. What is the next scheduled appearance in this other case?
Your Honor, the state's information is that in Butler County 25 TR 1215, there appears to be a bond, specifically a cash bond in the amount of $1,000 for an appearance date on July 30th, 2025 at 9 a.m.
All right. I'll advise the defendant that he does have a separate appearance requirement in a different case for July 30th at 9:00 a.m. I trust that would be in Zoom court with Judge Webster on that date, Mr. Regier?
That would be the state's presumption, Your Honor.
Okay, and then of course you've still got your Zoom appearance requirement in this court on Monday, August 25 at 3:00, Mr. Height. I think that concludes our business on
I have
your
one
case at this
further
time.
question. One further question, please. For this matter, the new hearing that you have just set, who is the judge and the court presiding?
The new one that I just said, you mean in this case that was before the court today?
Correct.
This judge is hearing the
Okay.
case. Okay.
Thank you for clarifying.
Well, let me clarify a little bit more. You got the short end of an already short stick when it came to your judge assignment. Because of all the Butler County judges you could have ended up with, you got Judge Ricky, who will gladly let you play your stupid game and will happily hand out your stupid prize, like he does with our next contestant.
Needler, it's case number 2024 CR 453. Amber Norris appears for the state of Kansas. Shannon Cooper is defense counsel. Defendant Needler appears from the Butler County Jail Zoom location. This matter comes before the court at this time for further proceedings. Back in February, the defendant failed to appear for a scheduled court appearance. Court ordered bond forfeiture, bench warrant, and no bond hold. The case was kept on the trial docket for April. At the pretrial conference, the defendant was deemed to be an absconder. Case was taken off the trial docket with the announcement that the case would be rescheduled for trial once Ms. Needler was picked up. The bond forfeiture, bench warrant, no bond hold order remained in effect. Eventually, obviously, Ms. Needler has been picked up. She's currently in the Butler County Jail. What announcement is made regarding the status of the case at this time, Ms. Cooper?
Thank you, Your Honor. Ms. Needler wishes to enter a plea of no contest to count 1. I did not hear back from Ms. Norris about whether she'd be willing to dismiss count 2. If her answer is no, then Ms. Needler would enter a no contest to both counts, but we were hopeful the state would be willing to at least dismiss count 2 and schedule the matter for sentencing. We'd also like to address a bond being set for Ms. Needler today. I anticipate that she would be presumptive probation for this case.
And Shannon, I did respond, but it actually is saying that you're not in the meeting. But yes, that's
okay.
your request
Okay.
Your request is fine.
Okay, thank you.
Ms. Needler, it's been announced that you now would intend to enter a no contest plea and accept conviction for count 1 in this case. I don't know if you have your charging document before you, but count 1 is theft, a level 9 non-person felony. Is that indeed your intention?
Yes.
I've got a number of questions I need to ask you regarding the taking of a felony plea. If there's anything asked of you that you do not understand as we go along, I'll give you the opportunity to confer privately with your attorney again. Just let the court know if you need that time to get further advice, okay?
Yes, Your Honor.
State your full legal name for the record.
Melinda Marie Needler,
How old are you right now?
32 years old.
What's the highest level of education that you've attained?
High school diploma.
All right. Do you believe you're going to have difficulty understanding any of the legal concepts we're going to be discussing in court here today?
No, no, sir.
All right. Have you ever been adjudged to be mentally ill?
No,
Are you currently under the influence of alcohol or any drug?
absolutely not.
Are you currently taking any type of prescription medication? Is that a no?
No,
All right. Are you supposed to be taking mental health medications that you are not currently getting?
no,
All right. So as you said today, do you believe your mind is clear and that you have a full understanding of what's going on here in court?
yes, Your Honor.
All right. Do you understand the nature of the charge of felony theft as charged in count 1?
Yes, Your Honor.
Have you had an ample opportunity to fully discuss legal matters like that with your attorney, Shannon Cooper, before
Yes.
proceeding here today?
Yes,
Are you satisfied with the services and advice given to you by your attorney?
yes, sir.
Now, this no contest plea that you're attempting to make hasn't been based upon any threat or promises as to what this court will do in regards to your sentence or any other type of threat or promise.
No, sir.
Is there anything that you thought was part of this plea agreement that hasn't been accurately discussed on the record already?
No, Your Honor.
Ms. Needler, do you understand that if there are any plea deals between your counsel and the county attorney's office regarding sentencing recommendations, that this court is not bound by any agreements made? The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes, Your Honor.
So let me ask you, how do you formally plead to the charge in count 1, felony theft?
No contest.
All right, so she's pleading no contest. Normally, this is the part where they set a sentencing date and they will reconvene to figure out what the sentence is going to be. And as both the attorneys already stated, there's a presumption of probation to be recommended as a sentence, but not everything is as simple as it seems.
The state would provide a concise statement of factual basis.
Your Honor, on September 23rd, 2024, here in Butler County, as noted in the information trailer with a welder and some tanks and welding wands and tools was taken from an address out in the county without the permission of the owner, who was Ben Griffith. And Your Honor, the trailer was located in the city limits of El Dorado within 24 hours of the taking. And the defendant was with two other individuals in the vehicle that had this trailer with all this equipment attached to it. And they were actively working on trying to appear to sell that piece of equipment either online or through electronic device, which showed that there was no intention for it to be returned to the rightful owner. And the value of the trailer and tools was well over $1,500.
Ms. Needler, do you now freely, knowingly, and voluntarily enter a plea of no contest and accept conviction for felony theft in count 1, a level 9 non-person felony?
Yes, Your Honor.
Ms. Cooper, are you aware of any legal reason why the court should not accept your client's plea?
No, Your Honor.
Ms. Norris, are you aware of any such legal reason?
No, Your Honor.
Ms. Needler, are you aware of a legal reason or any other good reason why the court shouldn't accept your no contest plea made here today?
No, no, sir, Your Honor.
Court will accept the no contest plea made by the defendant, Melinda Needler, and finds that that plea is made voluntarily. She has an understanding of the nature of her charge and the consequences of her plea, and a factual basis for the plea does exist. Court finds her guilty and adjudges her therefore convicted of felony theft, a level 9 non-person felony. Count 2 is dismissed pursuant to plea agreement. Court will order a pre-sentence report be completed to accurately determine Ms. Needler's criminal history, and the court will set an appropriate date for sentencing. We generally allow about 2 months for that pre-sentence report to be compiled and presented to the attorneys in the court. So we're going to be looking at early July. Also, if you check your availability for 11 o'clock a.m. on Monday, July 7.
Yes, that looks good to me.
Ms. Norris?
That should be fine, Your Honor.
All right. Court will set sentencing in the Needler case for Monday, July 7, 11 o'clock a.m. Obviously, Ms. Needler must fully participate in that sentencing proceeding at that time. It is contemplated that that sentencing be conducted by Zoom.
So she has a sentencing date of July 7th, and this took place a few weeks ago. So she has about 6 weeks to get her pre-sentence report done so she can even get on community correction. Now, those of you that are paying attention would have noticed that she's wearing a very popular color for people that we feature on this channel, known as Inmate Orange. And Judge Ricky never addressed her bond. Well, she's about to request him to do so now, and he's about to address it, just not in the way she was hoping.
Is there any way that we could address like a bond with if I get an ankle monitor?
Ms. Cooper?
Thank you. I would ask the court to consider that. Ms. Needler explained to me some of the circumstances surrounding her previous failure to appear. A person who was providing her with housing was also obligated to care for an elderly sick relative. And that person was in jail, so she took it upon herself to help with that sick relative. Was unable to come to court. She wants today to apologize for not following through or appearing until today, or until she first appeared. I think it might have been on Friday last week. But she assures me and wants to assure the court and counsel that she'll appear for sentencing. She'll cooperate with pretrial, with the pre-sentence investigation process with court services. She's sober now, wants to maintain sobriety. She's even looked into potentially residing in a halfway house. She, like she indicated a couple minutes ago, is willing to be monitored with a GPS electronic monitor to make sure she is where she's supposed to be at all times. So I'm asking the court today to set an OR bond, allow her to get back out and to get the treatment she needs, as well as participate fully in that pre-sentence investigation process from not in custody.
Does the state take a position on this request?
Your Honor, I would agree that the defendant will be presumptive probation from what I've seen in her history. Your Honor, based on the two failure to appear instances, one in February and one in April, I'm not sure that OR bond is necessarily appropriate, but I have no problem with the court setting an appropriate bond. I believe that this juncture, a no bond hold still remains on her case. Obviously, we've made some good progress today with the plea, so I'll leave that to court's discretion regarding amount.
Fair enough. Release her with a bond to ensure that she returns. Now all we need to do is get Judge No Fucks Given to agree.
Very well. Ms. Needler, earlier you suggested that you wanted to personally address the court about this?
Yeah, I mean, so whenever if I am able to leave here today, my plan is to go to stay at one of the Second Chance House here in El Dorado. I really honestly 100% was taking care of a 100% paraplegic man. I called my attorney the day that I had the first court, and I was minutes late, and she told me that it was too late already because I was on my way to her office at the time. I was stuck in Andover taking care of him at a hotel, and there really was nothing I could do. And because of me being scared of that warrant and of being in jail, that's the only reason I didn't come in. And I didn't even know about the second court date that you guys had scheduled. But I am willing to do ankle monitoring or whatever I need to do possible. But I really would ask. I don't have a whole bunch of money, but I understand it's probably going to cost me a little bit to get out of jail.
Ms. Needler, you said some surprising things that I'm going to comment on here. You were apparently walking and on some sort of device back in December when we addressed your case. At that time, the court accepted a preliminary hearing waiver at your arraignment. A court date was set for April the 4th for pretrial conference and a status conference in which you were ordered to appear at the Butler County Judicial Center, not your attorney's office, but at the Judicial Center, was set for February the 6th.
Yeah, that's the first.
Notes from February 6th indicate that Ms. Cooper was late, so we didn't start right on time. You weren't there, and the court ordered bond forfeiture, bench warrant on a no bond hold. Furthermore, docket notes indicate that we kept the case on the pretrial conference and jury trial dockets. So you had another court date set for April the 4th that you were given by this court back in December.
I know, and I
You were
apologize.
given 2 court dates. You just told me that you didn't know about it. Yes, you
Yeah.
did.
Okay, I apologize. I didn't realize that I had the 2.
Well, okay, if you showed up at either one of them, you'd probably be in pretty good shape right now.
I know, Your Honor.
The reality is you've shown yourself to be wholly unreliable to show up for any court date on your own.
Listen, Your Honor, I really, with the ankle monitor, that way you guys know exactly where I'm at and that I am doing what I'm supposed to be doing. You know what I mean? Because there's no way to be able to lie that way.
And how are you in your situation going to afford the cost of electronic monitoring?
I get disability every month. So I can pay the cost for it.
It could very well be that you may have to go through 1 or more assessments as part of the pre-sentence investigation process. If you're in jail, Ms. Needler, I have no doubt that court services will be able to find you and conduct those assessments. If you're out in the community somewhere, I don't have that confidence.
Your Honor,
Further,
wait, can I say one more
you tell
thing?
the court as a explanation as to what you're going to do now if you get out. You say that you're going to go to treatment and you're going to go to a halfway house, but this case has been pending in the system for 7 months and you haven't done those things.
Yeah, but no, well, that's not true. If you can talk to Don Kirkman. I was scheduled to go to treatment on Monday last week.
Yeah, I don't think scheduling your appointment for last week is really going to unpiss off Judge Ricky when he said that you didn't do what you were supposed to do when you had 7 months to do so.
I already went and got my SAC evaluation. I already had a plan to go to Grand in Tulsa, Oklahoma, to a treatment facility. Like that was already in place.
Okay, but you're in jail now.
But
so
right,
you
and
can't
that's
go
the
to
only
that.
reason that's the only reason why I'm not already there. And but those things were already set in place so that way I could get the treatment I needed.
All right. Well, I think there's a reasonable chance that I can keep you away from controlled substances by keeping you right where you are. I don't see any grounds here for an OR bond or even reinstatement of any bond in this case, with an electronic monitoring condition or not, Ms. Needler. I think you need to stay right where you are right now. I understand your attorney's request. I understand your statements.
Can I say
Even though
one more
you
thing?
were asking me earlier to listen, I have listened.
Wait, can I say one more thing? A very close friend of mine died yesterday, and I this is one of the biggest reasons I'd like to get out.
Well, I'll tell you what, Ms. Needler, you should have thought about that before you blew off court. You didn't surrender yourself on this deal.
Listen,
You had weeks and
I
weeks.
did
You could have
surrender
tried to
myself to
make this right.
Don. I did
Well,
surrender.
I don't think you and I arguing are going to accomplish anything, Ms. Needler. Court's decision is that I'm not going to reinstate a bond. You're on a no bond hold order due to failure to appear, not once, but twice on court dates that you were given by this court. So the court's order is going to stand. You're going to remain in jail at this point. We'll address whether you're eligible for release at your sentencing in July. And again, there are implications and consequences to you not showing up in court when you are supposed to.
Can I say one more thing also, Judge Ricky?
You can go ahead and say it. It's not going to make any difference.
Okay, well, so a lot of my why I was having issues getting to court was because I was set to not have any contact with Matthew Denny, and that's where I resided. So I was having a hard time with housing then, and I have housing now.
Indeed you do. Sponsored by the Butler County Sheriff's Office. And for the next couple of months, that's what your housing is going to be.
Damn, Judge Ricky. You could have just said no. Alright guys, that's the end of the video. It looks like we have a lot of Kansas shenanigans coming up. And I'm going to be there bringing all of it to you in the near future. So if you liked the video, hit the like button. If you disliked it, hit the dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content. I'm Team Skeptic, and I'm out.